extension of Line Mediation. I'm Dr. Anita. In the last video, I presented a real case of the parents who were separated and could not decide which one of them would actually make a decision about their son's vaccination. So the father took this case to court, and both the father and the mother presented their arguments, their evidence to the judge. So I invite you to watch that previous video because the judge is now about to render his judgment. So once you've watched the previous video, now the judge is, I see his lordship is coming. So with that in mind, all rise, and here comes the judge. Good afternoon, I'm ready to give my judgment. This is an application by the father to have the decision-making authority over having the child vaccinated. The parties are the parents of a 10-year-old child, Braden. They never cohabited. They signed the parenting agreement when the child was about 2.5 years old, and the mother had custody, which gave her the exclusive power to make all of the health-related decisions about Braden. The father says that the best interests of the child test should prevail on this application, regardless of the terms of this agreement. And I agree that yes, the best interests test applies. So why is the mother not willing to agree to vaccinate Braden? She cites two reasons. One is her freedom of conscience and her religious beliefs, and the other one is her own research, and I quote, based on careful science-based research of the safety and efficacy of vaccines and the listed unavoidable potential risks, contraindications, and potential adverse effects. I find that these arguments are not persuasive. However, what the court has is the evidence of the family physician, Dr. D'Souza. Dr. D'Souza, in her report, does state that at this time there is no clear medical evidence that Braden could not be vaccinated. And I note that her statements were not challenged by the mother. The father also accused the mother of delaying a court date, and as such, the parties now have the report from the immunology clinic that the mother requested the referral for. The report from Dr. Kim, the specialist, reveals the following. Number one, the child has been a healthy child. Number two, the child is not clinically manifesting any symptoms of any known primary immunodeficiency. Number three, Dr. Kim does not see any contraindications for the child to receive the immunization. Based on this, I find that there is no medical evidence that vaccines are contraindicated for Braden. Indeed, the mother's own affidavit states clearly that the child has been a very healthy child. I then find, on the balance of the evidence from the mother and the father, that the father should be granted authority to decide whether Braden should receive any of the existing publicly funded vaccines in the province of Ontario. The father is to follow medical advice about which vaccines Braden should receive. This case is adjourned.